On October 21st, 1909, the US government seized 40 barrels and 20 kegs of Coca-Cola syrup en route from Atlanta, Georgia to a bottling plant in Chattanooga, Tennessee. The seizure was authorized under the recently enacted Pure Food and Drug Act of 1906, and it was followed by a federal lawsuit that would ultimately make its way all the way up to the Supreme Court. And it was all over a substance we've all heard of, and some of us even use, for better or worse. Something that can give you a little pep in your step or keep you up late into the night. We're talking, of course, about caffeine. But why did the US government go after Coca-Cola, or more specifically, their syrup? What exactly did they have against its caffeine content? And wasn't there another stimulant in an old bottle of Coke that they should have been more concerned with? On March 13, 1911, roughly a year and a half after US government agents seized a shipment of Coca-Cola syrup, hearings began in a federal lawsuit, not against the Coca-Cola Company, but against that specific shipment of syrup. This is known as an in rem lawsuit, essentially meaning that the lawsuit's jurisdiction is of an object or property, not a person or corporation. The United States federal government was literally suing for syrup, and they were doing so on the basis of two main allegations: that Coca-Cola was misbranded and that Coca-Cola was adulterated with caffeine, which they claimed could cause injury. And we'll circle back around to the trial and its aftermath in a bit, but why was the US government going after caffeine? It's not like caffeine just popped up on their radar. Tea and coffee had been around for a really long time by this point. This increased paranoia surrounding humanity's most popular day-driving stimulant got its boost from a man named Harvey Wiley, who was head of the Department of Agriculture's Bureau of Chemistry at the time. If you've seen my previous video on the Poison Squad, I mentioned toward the end of that video that despite his overall net positive effect on food safety, Wiley's work had some flaws. Well, depending on who you ask and when, this might be one of them. Harvey Wiley, known as a crusader for food safety with a tendency to become a smidge overzealous, claimed that caffeine was a poison and was, quote, exactly similar in its chemical relations to strychnine and morphia. He likened it to opium and cannabis, claiming it to have a similar addiction potential. But what really got Wiley honed in on Coca-Cola versus the sea of other soda producers at the time was their sheer size, reputation, and the fact that they did not shy away from marketing toward children. By the end of the 1800s, Coca-Cola was already one of America's most popular soft drinks. To push sales, they gave away coupons for free drinks and plastered the Coca-Cola logo on pretty much anything. In advertisements, Coca-Cola marketed itself as a pep-you-up sort of beverage with the ability to relieve fatigue and cure weariness. And early on, despite the company continuing to deny it to this day, the early Coca-Cola formula did in fact contain cocaine. I've still heard some people argue that that's an urban legend of some sort, and that's probably due in part to Coca-Cola's century-long attempt to cover this up, but it is confirmed as being present in the early formula. However, it was a very small amount, roughly about 9 milligrams per serving, and was essentially a byproduct of the process used to extract flavoring from the coca leaf. That being said, the combination of the cocaine from the coca leaf and the caffeine from the cola nut did provide a moderate, stay-up-all-night, binge-reading Wikipedia articles type stimulation when consumed in larger doses. And not only did consumers know it for that, Coca-Cola used that to their advantage. That is, until the Department of Agriculture started clamping down on food and drug safety. In anticipation of problems to come, Coca-Cola proactively researched and implemented a process whereby cocaine would be removed from the coca leaf extract during manufacturing. And by 1903, cocaine was entirely removed from the final product. But with the potential problems they solved by removing the Peruvian marching powder from their formulas, came another problem. If the drink could no longer provide the type of stimulation that consumers expected from it, they might go elsewhere, and sales would suffer. To compensate for this, Coca-Cola increased the amount of caffeine included in a drink to roughly 80 milligrams per 8-ounce serving. And a quick but important bit of context to add to this. Coca-Cola was still primarily served out of soda shops at the time, with the Coca-Cola syrup being mixed with the carbonated water behind a counter. The amount of syrup included in a glass of Coca-Cola, and subsequently the amount of caffeine you would consume, could vary significantly depending on what shop you went to or even who served it up. But that increase in the caffeine content, coupled with Harvey Wiley's crusade against food adulteration and misbranding, put Coca-Cola into a very precarious position, one that would pit the United States government against a shipment of syrup in a legal battle spanning over half a decade. The seizure of the syrup in October 1909 was covered in the press, but the speculation was that the government was going after Coca-Cola for its cocaine content. However, when the trial kicked off on March 13, 1911, the public was surprised to learn that the government was focused instead on caffeine. The US government brought two main charges against the shipment of this Coca-Cola syrup. The first was that the syrup was in violation of the Pure Food and Drug Act of 1906 because it contained an added poisonous or added deleterious ingredient, in this case, caffeine, which might render the product injurious to health. The second was that it was misbranded, in that the name Coca-Cola was a representation of the presence of the substances Coca and Cola, and that the product contained no Coca and little if any cola, and thus was an imitation of these substances and was offered for sale under their distinctive name. Now, Coca-Cola did not deny that their syrup contained caffeine. It did. They freely admitted it, and they certainly marketed it as stimulating. The part they disagreed with was that caffeine was an added poisonous or added deleterious ingredient which may render the product injurious to health. They claimed that since the caffeine was derived from the cola nut, which was an ingredient in the syrup and not necessarily added to it, that it could not be considered adulterated in the legal sense. They also claimed that Coca-Cola was not misbranded because it was a brand name and not a descriptive name. So placing the misbranding claims aside for a moment, the biggest chunk of this trial really turned into a debate over whether or not the language of the Pure Food and Drug Act applied to caffeine that naturally occurred in ingredients used in the product, and whether caffeine itself had been proven to be poisonous with a potential to cause injury. The US government presented witnesses that claimed that caffeine was poisonous in large doses, citing side effects such as tremors, nervousness, heart palpitations, and even addiction. They cited instances where people would go to their corner soda shop every break to get their Coca-Cola fix, and would exhibit lethargy, headaches, and agitation when they couldn't. A lot of the government's case was based on either animal research or first and second-hand accounts of Coca-Cola's consumer behaviors and manufacturing processes. Since this was a jury trial, the government also presented evidence that seemed unrelated to the charges that they brought. For example, J.L. Lynch, an FDA inspector for the Department of Agriculture, detailed the pure filth rampant on the factory floor in Atlanta. He described a scantily dressed cook that swept up spilt sugar with his bare feet off a floor that he claimed had never been cleaned and was covered in chewing tobacco spit, only to put that sugar back into the kettle to brew the syrup. In another instance, the government presented a witness named H.C. Fuller, who was a chemist from Massachusetts, who claimed to have found hay, insect legs, dust, dirt, and even part of a bumblebee in a sample of the syrup. He even brought the paper filter he found that stuff in to show the court. And this next one is, I think, my favorite. The government called into question the direction of the doors of the toilets on the factory floor, noting that after somebody dropped a deucer, the only direction that those fumes could ventilate to was straight into the brewing room. You can read through the trial transcript yourself, almost in its entirety, I think. It's hilarious though. It reads like a sitcom script. The attorneys misunderstand each other in like a who's on first situation sometimes, and some of the witnesses that they called give testimony that's just kind of bizarre. I recommend it. But anyway, the US government aimed to turn the jury against Coca-Cola from the very beginning, and they weren't against using disgust as a way of undermining the positive image that the brand may have already had with the public. Coca-Cola, on the other hand, came a bit more prepared than Harvey Wiley and the US government may have anticipated, having scrambled to put together their own research before and even during the trial into the actual health effects of caffeine. A professor at Barnard College named Harry Hollingworth was recruited to put together human experiments and gather data for the defense. He provided his human subjects varying doses of caffeine and gave them 20 tests each time to test their cognitive, sensory, and motor abilities. In the third week of the trial, Hollingworth testified that there were mild stimulant properties to caffeine that positively affected cognitive and motor abilities, but that had no deleterious effect on those abilities. So, unsurprisingly, Hollingworth, who was recruited by the defense, testified in favor of the defense. When it comes to the misbranding aspect of the case, the trial actually never got around to it. The judge ended up dismissing the case in favor of Coca-Cola as he did not find that caffeine was an added ingredient to the syrup, and therefore, by definition, the syrup was not in violation of the Pure Food and Drug Act. But the US government, not known for their ability to accept defeat so easily, appealed and, well, lost. again. So, of course, they appealed again, and the case went on to be heard in the Supreme Court in 1916. The Supreme Court's ruling contradicted the lower court's ruling. The Supreme Court stated that under the Pure Food and Drug Act, an ingredient could be considered added if it was proven to be deleterious or have the potential for injury and was introduced in later stages of production, regardless of whether or not that ingredient naturally occurred in those later stages. As for the misbranding charge, they ruled that essentially nobody had provided enough evidence to make a determination on this from either side. The case had become too bogged down in the caffeine, and it was dismissed by the lower courts before it even made it to the misbranding charge, so they made no ruling on it. The US government won the appeal with the Supreme Court, which essentially meant that it was just remanded back to the lower courts for a retrial and judgment. But throughout this trial, Harvey Wiley, the guy who originally headed the charge against Coca-Cola, was more or less forced to resign by then President William Howard Taft. There's a whole can of worms about how much political opposition Harvey Wiley faced in his career with the federal government, often due to butting heads with corporate interests who were at the same time aggressively pursuing their own interests with politicians in DC. We won't go down that rabbit hole in this video, but he was essentially bullied out of government by people who benefited from prioritizing corporate interests. With Wiley gone, somebody else had to head up the case against Coca-Cola, but that job had proven to be a professional death blow to Wiley, and few others dared to take his place. But before that could even happen, Coca-Cola proposed a new deal. They would voluntarily surrender the shipment of Coca-Cola syrup, cut in half the product's caffeine content, and pay all legal costs the government incurred during the original trial. In a show of sincerity and probably an overwhelming desire to rid themselves of this constant stream of legal chicanery, they had already followed through on cutting the caffeine content effectively in half to about 38 milligrams per 8-ounce serving. And this new deal, coupled with the hesitancy of politicians to risk their own careers opposing corporate interests, resulted in the US government dropping their case entirely. And so the 7-year legal battle between the United States government and Coca-Cola came to an out-of-court compromise that could have realistically been reached much sooner if Coca-Cola had just been a little bit more open to negotiation from the beginning. Today, there is a legal limit to the amount of caffeine that can be included in carbonated sodas like Coca-Cola, and it's a surprisingly low 71 milligrams per 12 ounces. But you and I can probably both name plenty of drinks off the top of our heads that include way more than that. And it turns out, you can easily get around these limits if you just classify your beverage as a liquid dietary supplement. If you make that legal distinction, then boom, this is not a carbonated soda. It's a liquid dietary supplement that is no longer subject to the legal limit of caffeine set forth by the FDA. It doesn't matter if it opens like a soda, smells like a soda, tastes like a soda, or even sounds like one. There's also no legal caffeine limit on foods and beverages with naturally occurring caffeine, like coffee. Some brands take advantage of this loophole by throwing coffee or tea extracts into their products, simply to add however much caffeine they want without violating FDA regulations. There have been calls in recent years to update the FDA's caffeine regulations, which are seen by some in the scientific and medical communities as incoherent and Byzantine. And there have been actions taken against products that contained too much caffeine, or caffeine mixed with other ingredients that could result in or contribute to injury or death. But for the time being, we're pretty much free and clear to create, consume, and caffeinate whatever we want, however much we want, so long as any damage that it might cause doesn't get too much media attention and we don't call it soda.